to another lecture on intellectual property rights, copyright law. So, in the last lecture, we studied the three cases: Baker versus Selden, Walter versus Lane, and Canadian Limited versus Law Society. And in this lecture, we'll be focusing on the first Indian case, which is Eastern Book Company versus University Press. And then we'll go on to Feist Publications versus Rural Telephone Services. Now, these cases are again about surrounding what is copyrightable, what type of material is copyrightable, and basically does also go into the same test that we spoke about in the last video. That is the sweat of the brow test and the modicum of creativity, minimal amount of creativity required. So, to begin, we'll be dealing with Eastern Book Company versus University Press. So, I just realized so from the last video, I say a lot. That's such a bad habit. But I'm going to try and not do that anymore. So, Eastern Book Company versus University Press. EBC. Now, EBC is a leading publisher of law reports and journals in India. And if you have studied law a lot, I don't know, because a lot of the LLB courses have IPR in the beginning, but the BA LLB courses have IPR towards the end. So you may have come across EBC, but it's basically a leading publisher. And in this case, EBC actually alleged that two defendants, that was Spectrum Business Support Limited and Region Data Tech Private Limited, they started marketing these software packages infringing EBC's copyright in SCC. Now, SCC is Supreme Court cases. It's basically takes judgments and publishes them, but not just the judgments. They include a lot of head notes and these editorial notes which help you understand the judgment much better. So that's what EBC does. So it doesn't just verbatim publish a judgment, but it publishes it in a way which is readable by the readers. So, what was happening here was that, as per EBC, all the modules in the defendant's software packages had been lifted verbatim from SCC. So they just taken everything straight away, including the head notes and the editorial aspects, right? So the issue, of course, in this case was what is the standard of originality in a derivative work to get copyright protection? That is referring to EBC's work, whether EBC's work has copyright protection because technically it is using judgments, but are the head notes and editorial notes enough to give it an original, connotation of it being an original work to grant it copyright protection? And the second issue is whether the edited version is entitled for copyright, right? Which is obviously connected to the first issue. In order to prove whether the defendants in this case have infringed the copyright of EBC. So, although this case it's extremely long, the judgment, it's, I think, over 100 pages long, and it's quite repetitive but also a little confusing, to be honest. It makes little sense to me, and I feel like it ends up being very similar to it ends up taking a standard similar to the Canadian standard, but it also like mixes in the English standard and like creates a own test of its own. So maybe right now this doesn't make any sense, but as we get into the analysis, you'll understand. But yeah, the actual crux of this judgment is literally in like a few pages of the judgment, which is what I am briefing you about here. So I would suggest not to read it, but I don't know if that's the best suggestion. Uh, okay, so the analysis of the case. Now, what the Indian courts do in this case, the Supreme Court does, is these are the rules. So, firstly, these rules there are sections in the Copyright Act. You can go over them. It'll help you better understand the case. But these are basically the sections that are referred to in the judgment, which is what is important for you to know. So I've just literally written everything that is important for you to know, so that you can actually, if you're in a rush, not go through the judgment. Um, yeah, which I advise you shouldn't, because it's quite confusing. But what the court said in this case is that um, for a derivative work to have a copyright protection, it should show that the work is more than just a copy of the original. That is, it should have used labor and independent skill. So they say that mere copy editing wouldn't suffice, as this involves mere labor and nothing else. But since in this case there is some creativity involved in making head notes, that is, EBC was making head notes, they were making certain edits to help you understand the case better. So these head notes would qualify as copyright protection according to the court, because they are adding this creative value to the work. So of course, this is similar to what we discussed in the Canadian case, um, which uses the test of a certain amount of creativity. But the court still refers to the sweat of the brow test also, which is what makes the judgment a little confusing, because they say that yes, the sweat of the brow doctrine applies, but not just that doctrine. We're going to take like a middle path approach, which is about the exercise of skill and judgment. So technically, it's a newer test, which is a combination of modicum and sweat, which sounds a little weird, but yeah, it's an in between standard. But at the same time, they've given this in between standard, but they've not really explained it well enough. So they say that, skill is the practiced ability to do work, and judgment can refer to both the sweat of the brow and modicum. So this is what this new rule is. Depending on your interpretation of skill and judgment, um, you can state whether a work has used a certain amount of skill and judgment to be given this copyright protection. So it's very weird, because technically it's based upon the court's interpretation in the future of skill and judgment. They've not really narrowed it down. They've given this broad overview of like this meshed thing of sweat doctrine and minimal creativity, but they obviously do state that the author must apply skill and labor for it to be to get original copyright protection. So according to me, at least, I feel like it is very similar to the Canadian standard. And also according to me, I feel like no one is approving of the English standard, neither the Canadian courts, neither the Indian courts, neither the US court, which you will see in the next case. They all are saying that the sweat of the brow doctrine is too less, it's too little, it's not a high enough threshold. So yeah, so the Supreme Court concludes by saying that the appellants were publishing these law reports in the name of SCC, and so they cannot publish. The appellants were publishing law reports in the name of SCC, that is EBC, and that the defendants that were using the same thing verbatim, they cannot be using that same thing verbatim, because the appellant's work has copyright protection, because it is original, because it has creativity, skill, and judgment, in the sense that they are making head notes and editorial notes. That is why it becomes an original work. That is why it is protected by copyright. And so you cannot copy that. But of course, you can use judgments. That is a whole different thing. You cannot copy the way EBC has written it with the head notes and everything. So they say that they ended up restraining the respondents from copying head notes, footnotes, and editorial notes that were appearing in the law journals, because of the fact that EBC has copyright on those notes. But yeah, when you do study this case in college, I'm sure the professors will also tell you how this judgment makes very little sense. But I have tried to brief it in the best manner that I could think of, and hopefully you understand the crux of the judgment, which is exactly this. Now the next case is Feist Publications versus Rural Telephone Services, and this is a US case. Again, here you will see that the US is also totally against this whole English standard of sweat of the brow. They're like, it's too little, it's too low a threshold. Um, yeah, so that's what they say in this case as well. But it's quite a different case as opposed to the previous ones we studied. So in this case, the facts of the case are that there is this rural telephone services company, right? And it published these telephone directories, right? And they had got into these negotiations with Feist Publications, and they were trying to sell their phone number listings to Feist Publications, right? But what happened was during the negotiations, they had some falling out, and Rural had refused to license the information, but Feist still copied the information. So technically, it was they felt like it was copyright violation, and they said that you have violated our copyright because you have copied this whole phone book directory. Now, what the court said, and what Feist also argued in this case, was that this, uh, you know, this phone book directory is not copyrightable in the first place, because phone book is literally just a list where there are like three types of listings, of phone book listings. I'm sure like none of us really know, at least if you're studying IPR now in university, not really like very familiar with phone books. But phone books literally have these three white pages which have like numbers of people in your locality. Then they have yellow pages, which is number of like business companies, and then there's blue pages, which has the numbers of government employees and government phone numbers basically. So yeah, so they have these listings, and they're just, this is basically just how it is, it's fact, right? And everything in the phone book is fact. I mean, it's just numbers, it's just the order, and there's only one way to order a list, like it's alphabetical, that's the simplest way, and like that's one way to order it, right? So it was quite strange that this case had come to court, that this was an issue. Of course, this was to be dealt with at that point, but it's quite clear that this is just fact, and that a phone book directory cannot be copyrightable, right? It's just a compilation, it's a comprehensive compilation of information that is fact. So there was no skill that was, you know, used to gather this info that could be, could make it capable of deserving a copyright. So what the court actually said was that common sense tells us that, 100 uncopyrightable facts don't magically change their status when they're gathered together in one place. So the intent of copyright law was not as Rural had claimed in this case, and that some lower courts actually also have claimed, to reward efforts of persons collecting information. You can't say that copyright law rewards people who can collect information and comprehensively compile it. That's not what it is. And they also spoke about the sweat of the brow theory, and that how this standard of creativity again is extremely low, as I mentioned earlier as well. And that in such a case, since this is not the purpose and intent of copyright law, since these are facts, since it is simply the job of collecting information, this phone book, this phone directory is not copyrightable, and so Feist Publications has not violated any copyright. So the facts are not copyrightable. Information alone without a minimum or original creativity cannot be protected by copyright. There is no original creativity. There is it does not pass the minimal standard, and as we said, they of course rejected the sweat of the brow standard. So anyway, their standard was higher than that, and in this case it did not fit. So yeah, this is exactly what Feist Publications said. It further solidified the idea expression dichotomy, and also a lot about how facts cannot be granted copyright. And with this case, we sort of move on from the whole basic introduction of copyright law and the sweat of the brow, modicum of creativity, even though these concepts will be coming up in the future. This is sort of the law and what we understand of it as of now. um, and hopefully, and I'm sure, sorry, I know actually that the cases that are to come are way more interesting and way more fun to study. This just set the base of what is copyrightable and what is not copyrightable. And yeah, I hope you understood everything well enough. um, if you have any questions, the comment section below. I will see you in the next video.